This is a revamp of an old talk I gave early in my library career about female ancestors and the unique challenges they pose. Interestingly, over the last decade, I've had many more distaff side breakthroughs in my family history. The number of unknown grandmothers in the most recent 7 or 8 generations of my family tree has really dwindled. And that's saying something because half of my family is from South Carolina and the other from North Carolina. Both are challenging places to work on your grandmothers, but South Carolina especially so due to a lack of civil registration of marriage prior to 1911. So this version of the talk reflects greater experience and greater success, much of it due to genetic clues. I'll confess, I had to drop one of my examples and replace it because genetic matches have revealed that I took a wrong turn in identifying one of my female ancestors 10 years ago. So let that be a warning to you. Distaff side research, so called because the distaff was a tool in spinning cloth, and this was a task considered characteristic of women, hence the term spinster for an unmarried woman. That kind of research is a difficult area, and it's one prone to mistakes and confirmation bias. Once you get a theory in your head about who your fifth great grandmother was, based on whatever evidence, the more difficult it can become to change gears when you discover conflicting evidence. You tend to see everything else through the lens of your pet theory. Also, I need to tell you that there is a handout to accompany this talk. It contains a timeline of events called landmarks in the legal status of women in North Carolina, 1741 to 1868, a bibliography, of course, and a glossary of legal terms. So if you want a copy of that, you can write to me at larry.cates@highpointnc.gov. You see it here on the title slide, spelled out for you at the bottom in yellow. And if you do that, I will send it to you in a PDF format. So if you are like me, many of the blank spaces in your family tree radiate backwards in time from female ancestors whose maiden names you just don't know. There are many reasons why this tends to be so. Female property rights were very limited in the 19th century and before, and property is the most common reason why people appear in public records. Only single women and widows tend to have significant rights in this regard. They were known as femmes seules for legal purposes, meaning women empowered to act alone. But most other women were considered extensions of the men in their lives, and as a result, we sometimes have difficulty identifying them. Often it's a matter of finding their maiden surnames and the appropriate family of origin. Sometimes, particularly in the colonial period, or for women who died young, even her given name may be unknown to you. So what can you do in such a situation? The first step is to define the legal parameters better so that we'll know what to expect in the records. Most women were defined legally by their relationships to their husbands, and as minors by relationships to their fathers. This concept, as it related to marriage, was known as the doctrine of unity of person. Court cases on behalf of women, therefore, were brought in the names of their husbands, not in their own names. Men had control over their wives' property during the marriage. A woman could not contract debts or be sued for obligations her husband had not authorized. That's why you'll sometimes see a notice from a husband printed in a local newspaper advising no one to conduct business with his wife, and that might be an indication that they were legally separated or that she had run away. While husbands lived, women were considered as being under coverture. They were, in other words, legally subsumed within the legal person of their husbands. Only at the death of the husband did women begin to have limited property rights and legal individuality. There are a couple of ways to get around these restrictions. Women could arrange to have prenuptial agreements made where they divided with their husbands exactly what property belonged to each party. And fathers then could also leave daughters' property in trust so that a husband could not touch it. The legal instrument enabling this arrangement was either a deed of trust or a clause in a will. And in both of these cases, a man was also usually involved, that is, another man besides the husband or the father. He was the trustee into whose hands the property was committed to protect it from the husband. Of course, the trustee who was often a relative or a lawyer or some other responsible friend of the family, had no power to dispose of the property committed to his care. He was required to preserve it intact for her benefit, unless a court order directed otherwise, or more often, it was preserved for the ultimate benefit of the children. But it's still an irony that a man was usually the protector and the woman the protected. In other cases, men sometimes liberated their wives to act as individuals. This happened when men became incapacitated and depended upon their wives to perform business, or when women owned their own enterprises and insisted on having control. You'll sometimes find these instruments making women sole traders in deed books, but that is a rare eventuality. Unfortunately, women were placed in the same category with women or people who were not mentally competent, and therefore they were considered not able to take care of their own affairs. As a result of their legal invisibility, women can sometimes seem to be invisible in public records, and that's true more so as you go back in time, actually. Women executed far fewer legal documents than men. You'll still find that they executed wills and signed off on certain deeds, so you should definitely look for them in these places, but expect this strategy to disappoint you regularly. Here I give you an example of a prenuptial agreement made by Flora McRae with her husband, prospective husband, James Pearl, in Montgomery County, North Carolina, in 1852. And she was a widow by this point. No, I'm sorry, she was not a widow, but she had received an inheritance from her father, Alexander McRae, and she was concerned that she would not have control over some of her property that she'd inherited and that Pearl might not take good care of it. So they both agreed to allow Alexander Dunn, who was, I believe, her nephew, to hold this property in trust for her and her descendants. And here's an example of a clause in a will, one of Daniel McRae of Mangum, North Carolina, in northern Richmond County, where he's leaving some enslaved people to his daughter Mary and making sure that it remains her property in her lifetime to be handed on to her children and to be separate and apart from the control of her husband. So, if women were so hobbled and belittled by the law, why would you find them listed in wills or deeds at all? A woman did have a right to dispose of anything she obtained after the death of her husband, or anything that she owned in her own right. Sometimes she owned property in this fashion because her husband granted her fee simple tenure in a deed or in a special provision of his will. Sometimes because it was given to her by one of the trusts we mentioned earlier, sometimes because she purchased it herself as a single person or inherited it. Unmarried women did have extensive control over their property. When women made wills, it was usually because they held this kind of property. However, you'll notice that most women's wills include far more personal items than real estate. Even married women had some legal interests in their husband's property during his lifetime. Rights varied with changes in the law at different times and places. Laws were different in each state, and they evolved over the generations, so you have to check them carefully. The concept is known as dower, and it should not be confused with dowry, which is a marriage portion set aside by the bride's father for the benefit of the new couple. Dower, on the other hand, arises from the recognition that a woman is dependent upon her husband's judicious use of his own property so that she and her children could have an adequate living. If he was irresponsible, she would be the one to suffer, and therefore it was thought advisable to give her veto power over his real estate transactions during his lifetime, including any land he brought into the marriage or that he acquired afterwards. This kind of dower is called dower by common law or inchoate dower. Inchoate literally means only partially existing, or not fully formed. So it's really a shadowy and partial right. It explains why you will see married couples signing deeds together in the old days. Her right of dower had to be signed away explicitly by her and without coercion. That's why she was entitled to a separate examination apart from her husband, so that he could not influence her. Of course, they didn't forget. I suppose they did forget that at the end of the signing uh, event, she would have to go home with her husband. But if free release of her dower was not obtained, the omission could call into question the purchaser's rights in the property that was conveyed by that deed. In North Carolina, inchoate dower applied in the colonial period up to 1784. It was abolished during the entire antebellum period, but was brought back after the Civil War in 1868. It continued in force until 1960. Different laws and timetables apply in different states, so check the legal history of the jurisdiction that you're working in. A quick way to do that is listed in the reference guide that accompanies this talk, and it's provided for each state in Christina Kasabian Schaefer's The Hidden Half of the Family. So request the handout if you'd like the reference to that book so you can remember it. During the antebellum period from 1784 to 1868 in this state, women retained a form of dower rights, but this did not become active until the husband's death. This aspect of dower, which also applied in colonial times, is called consummate dower, meaning fully matured as opposed to the inchoate dower we were talking about just before. It applied only to lands that the husband owned at the time of his death, not to the lands that he brought into the marriage or purchased during the course of their life together. When the husband died, a woman had a right to 1/3 of the landed property he owned at that time for the remainder of her life. She could use it and live from its proceeds, but she could not sell it or mortgage it. She could not waste it irresponsibly. She had to preserve it for her children, or, if he had no children, for his siblings and their heirs. Now, she could sell her dower right for her lifetime in the property. She just couldn't sell the property itself. If her husband left less than 1/3 of his land to her in a will, she had a right to sue for her dower. That was the bare minimum that she was entitled to. Now, it's possible that she might not wish to do this if her husband willed her some land in fee simple, that is, giving her total control of it. She might have elected to keep that instead of suing for dower. But usually the dower tract contained the house and the major outbuildings. She also had a right to a year's worth of supplies from the personal estate before the rest was sold to acquit any debts that were owed by the deceased man. That's called her year's support. Because inchoate dower had been abolished in North Carolina, if you see a woman signing with a man to alienate property in the antebellum period, it could mean several things. She's certainly not releasing her dower rights, unless the couple maybe came from another state where the old dower law still applied and they were not totally aware of the law in the new state. It's very possible that the property they're selling, however, came into the marriage through the woman if she's signing in the antebellum period. On the other hand, it could be that the woman signing the deed is not the seller's wife at all. It could possibly be his mother, for example, signing away her dower interest in an inheritance from her deceased husband and his father. And here's an example of a tract of land that belonged to Duncan McCrae, who died about 1820 in Anson County, and they divided most of the land into little pieces for each of the children. I guess there were over 10 of them. There are quite a few of them here. But in the middle, smack dab in the middle, you see the dower tract labeled just that way. It's about 1/3 of the total. It's not technically 1/3 of the land itself. It's 1/3 of the value of the land. It might be the most valuable piece, usually was. And in this case, Edith McCrae, who was the second wife of Duncan McCrae, she got to enjoy that land for life, and then it had to go back to the other heirs at her decease. So clearly, one of the ways to determine who a woman's parents were is to track all the land that came into a family and all that was sold during the marriage and compare what's left over to what was accounted for at the death of the husband. Anything that was not purchased by him, was not granted to him by the state, or inherited from his side of the family could have come through the wife's side by inheritance. Tracking that land might lead to maternal ancestors. Also, any land the woman signed away in North Carolina during the antebellum period should receive special scrutiny for the reasons that I've just outlined. That land could have been inherited through her since she had no inchoate dower rights from 1784 to 1868. However, you must remember that for much of American history, there was a prejudice against leaving land to daughters. In the colonial period in North Carolina, for instance, and in most southern colonies, land could be entailed. That means a person could demand when he handed over property to his son that it remain in one particular lineage forever, usually through a male line. Women weren't thought to need land because their husbands would provide it. Of course, a man could divide his land the way he chose by an explicit provision in his will, even in the colonial times. But mostly land went to sons, and some personal property to daughters, usually furniture or livestock, occasionally enslaved people. In fact, daughters who were married prior to their father's deaths often received no mention in his will at all. It's a very disappointing fact, but it's probable that the older daughters had already received a marriage portion at the time they wed, and that was considered sufficient. Sometimes these marriage portions appear in the deed records, particularly if they involve slaves, but this is also relatively rare. The easiest form of personal property to trace is definitely enslaved people because their names remain fixed. I'll give you an example soon where the name of an enslaved person given to a daughter in 1769 helped to prove her identity. If a man died without a will in the colonial era, all of his land would go to the eldest son in North Carolina. His personal property would be divided among all the children. Records of such divisions are very rare that early on, and so many of the heirs are not visible looking merely at an intestate estate record. At least the widow's name is likely to appear as her husband's administrator or in relation to the dower being laid off to her. If a colonial man died intestate without sons, however, his land would be divided equally among his daughters. Later, after the Revolution, for a brief period from 1784 to 1795, all the sons inherited the land equally. The daughters were again excluded from real property. It wasn't until 1795 that an intestate person's land would be divided equally between sons and daughters, share and share alike. The descent of land under these laws of intestacy is important evidence for identifying women's maiden names between 1795 and the modern era. The problem is knowing which family's wills and estates are likely to mention an ancestress and her husband. If the bequest or division happened before she married also, keep in mind, it will be necessary to prove that the property transferred to her as an unmarried female later shows up in the possession of her husband. Of course, what we all hope and pray for are explicit records of marriage, like the ones pictured here. These are the two major types of marriages in North Carolina. Before 1868, we mostly have marriage bonds. These are not very informative. They give the name of the intended bride and the groom, the date of the bond, and the name of a bondsman, who may be a kinsman to either the bride or the groom, or he might just be a friend or somebody who happened to be in the clerk's office on the day the bond was applied for. Occasionally, the actual date of marriage is attached and the name of the officiating minister, but this is rare and more common later in the period. The existence of a marriage bond does not prove that a marriage actually took place. The bond was initiated in order to guarantee that there was no lawful impediment to the marriage, like unlawful degree of kinship between the parties, coercion, bigamy, interracial marriage, and such like. The penal sum of the bond became due to the governor if the marriage could later be proven to be unlawful. There's several things to remember about marriage bonds, and I've mentioned a few of them and alluded to them at least in these last few passages. But one is that they're spare on detail, and you can see an example on the left here. They do not prove that marriage actually took place, and you can imagine a situation where somebody would get a bond and then get cold feet and not go through with the marriage. That definitely happened. Many were never properly filed or disappeared from courthouses before they were sent to the archives. In the county where many of my ancestors lived here in Randolph County, for a long period of time, we had an informal county archivist in the mid 20th century who reportedly let people come into the office and borrow or even take records that belonged to their family. And there are even some marriage bonds that we can prove did exist that no longer are in the official records of the county. There are others that have been found in other places, like in a private genealogist collection that was later turned over to the archives. So there are lots of gaps, lots of missing records. Finally, perhaps a majority of marriages before 1868 never involved bonds. Creating a bond involved paying a fee, and many people simply couldn't afford that, or they found it inconvenient to travel to the courthouse. So there was an alternative procedure in place to get married, and that's called declaration of the banns. That happened on 3 successive Sundays in the church of the couple's choice, the church where they intended to be united. This gave them the community an opportunity to raise objections to the marriage in advance if they were aware that there was some impediment to it. Now, the licenses after 1868, and you see an example here on the right, were mandated and had to be returned with the date of the marriage and the witnesses' names recorded in the certificate portion at the bottom of the form after the ceremony was held. The licenses also provide additional information at the top about the bride and the groom, how old they were, who their parents were, if their parents were living or dead, and if they were alive, where they were living at the time. So they are godsend, and they are required, they're mandated. You can't have a legal marriage after 1868 without a license. But there are some counties in which early licenses have been discarded, unfortunately, probably because they were taking up too much space. And in those counties, only the marriage registers, which are kind of a condensed index to marriages, may remain, and they often, or most of the time, actually give less detail. So you can get lucky, and then you might not get so lucky. Under slavery, of course, no marriage was allowed. This maximized the rights of masters to do what they pleased with their so-called property. In 1865, freed people were encouraged to come into court and declare their relationships in what are now known as cohabitation records. The maiden names of former slave women recorded are actually oftentimes references to former masters, which were often not the same people as their husbands' masters. Surnames have different import for slaves than they do for free people. They need not refer to former owners, but they often do. Usually the children born in slavery would also be the slaves of the mother's master, not the father's, because slavery followed through the female side of the family, the demonstrable side of connection between mother and child. Cohabitation records may also provide a year when the union of the two parties actually began, and it may refer to the number or the names of the children that have already had together. In certain places like Virginia, there are even more informative records in certain counties which provide the residence of the person prior to freedom and the name of the former enslaver. But the normal cohabitation record anywhere just includes the names of the two parties who are getting or who are recording their union and the date the cohabitation record was made. Now that we've reviewed the names, or rather the types of marriage records here in North Carolina, we need to make a painful acknowledgement. Explicit civil records of marriage are often unavailable rather. In fact, in certain periods, they're very much the exception. So what can we do when we can't find a marriage record among the civil records of the county? Well, clearly there are some other places to look when you cannot find that civil record. Some of these are generally applicable, and some are peculiar to North Carolina. Now, family Bibles may give an explicit date of marriage and a maiden name of the woman. There are large collections of family Bibles at many universities and state-level archives, but don't neglect to find other descendants of the family and inquire with them. Most family Bibles are still in private hands. Some have been published in books, some have been published in local genealogical society publications. Newspaper abstracts are marriages are frequently recorded in brief notices for white people of a certain class. Not everybody got a mention of their marriage in the newspaper, but it's worth checking if you know a newspaper existed in the place where your ancestors were married. If you can determine what churches your ancestor attended, you should check to see if that church kept the marriage register. Sometimes the church historian still has the records on site in the church itself, but most of the time, these older records have been turned over to a larger archive, like the North Carolina Baptist Historical Collection at Wake Forest University. Some records have been published, like Henshaw's Quaker series, or the records of the various Anglican parishes in Virginia and Maryland, or some of the Lutheran and Reformed churches in North Carolina. Some pastors kept private records of marriage among their personal papers, which may exist in private hands or a public archive. Some such registers may have been published and indexed in collections of local records or genealogical journals at the local level. Not every denomination kept marriage records. The Baptists are a good example. But the chances are high that a marriage took place within a particular confession or congregation, and if you know which one it was and there are records for that church, it's good to survey them for the names of the male and female parishioners that show up in various lists of people who took communion or membership rolls. It's just possible that your ancestor married somebody that they met at church. In the late 1780s, there was a law in North Carolina that mandated temporarily all license fees collected by county clerks had to be reported to the state treasurer's office, state treasurers and comptroller. And many of these records remain in those papers. Some mention the maiden name of the bride in that brief period. They have been published in the North Carolina Genealogical Society Journal by county. It is possible to trace the maiden name of the mother to the death certificates of the children who survived into the early 20th century. It's particularly nice to find more than one child's certificate in agreement about her name, however. Maiden names are not always revealed in these documents, and you must remember that they're sometimes incorrect. It's also possible that marriage licenses of children might reveal the maiden name of their mother. That's more common in Virginia than North Carolina, but many North Carolinians cross the state line to marry. Genealogists who publish abstracts of records are a blessing to us all. If the county where your male ancestor resided has had records indexed and published, you should certainly check them for evidence of his wife's family. Problems will occur when the wife's family did not explicitly leave her any property or when they did not record the transfer. And also there will be instances when the property transfer happened before the woman was married and there's no evidence of her married name in the public record afterwards. Divorce petitions often state the date and place of marriage and the maiden name of the wife. Her kin group is sometimes involved as witnesses as well. And then military pensions applications and applications for bounty land always require proof of marriage when the widow is the applicant. Sometimes a lady will reveal the date of the marriage and her maiden name. She may even obtain a transcript of a marriage record, which may or may no longer exist in the public domain. She may obtain affidavits from individuals present or aware of the marriage if she can't get that certificate or bond. But what happens when you know only the wife's given name and you have no idea which family to look into as her potential family of origin? One thing you can do right away is look at the Christian names given to the couple's children. If you know the husband's side of the family well, you may find clues to the mother's side through process of elimination of favored given names from the paternal side. The remaining names given to the children may come from the wife's side. Keep in mind that you can further narrow your search by looking at families that share similar social characteristics. For instance, you would not expect to find males high on the social scale marrying females from the poorer end, though this can happen, of course. It's more likely that you'll find men lower on the social scale marrying upwards or marrying an equal. But the best policy by far is to look at and record every name that appears alongside the husband's in any record that you can find. We call these his associates. Sometimes it's called the fan club, friends, associates, and neighbors. I include a chart with the handout that will help you to record them. One chart per individual or kinship group that you are suspecting might be related through the wife. They are the people who transact business with him, who go to the same church, who witness his legal instruments, who serve as bondsmen or securities for him, or for whom he served as a bondsman, who sponsor his children in their baptisms, anyone with whom he buys or sells land, those who appear in court for him, co-sign his promissory notes, purchase property at the same estate sales, move with him from one location to another, serve as his administrator or executor or the guardian of his children, etc. The more risk the associates take on the husband's behalf, the more intimate the situation in which they are associated together, the more likely they are to be relatives. Of course, you have to be quite familiar with the husband's birth family, both paternal and maternal, to begin with so that you can distinguish the wife's kindred from the husband's. By the way, also look at all the records that the children of the couple left behind. We generally have ongoing relationships with our cousins and uncles and aunts on our mother's side of the family. In fact, in former generations, kinship networks retained strength across several generations. So it may not just be the husband's associates who are relevant, but also those of his children and his grandchildren. Looking at them all as a group may build up quite a record suggesting relationship. But also remember that there are other potential explanations. Simple friendship or neighborliness may be behind the apparent patterns that you're finding. This strategy requires that you make a blanket search of the records first, looking into every nook and corner that you can possibly think of in search of association. That means include difficult records like court minutes and papers in your search. Once you've listed these associates, pick the ones who seem to be the strongest candidates first and investigate their families. Find out if there's a female of the appropriate given age and name to be your grandmother, taking care to determine whether or not the candidate female likely married someone else. Once you've eliminated those, you can work down the list looking at the less likely candidate families. I've seen many cases in which only a couple of records will associate the grandfather with the family he married into. In some cases, you'll never be able to prove your case beyond a shadow of a doubt, but you may end up with a very likely candidate and have a good set of evidence to support your conclusions. I want to continue here by giving you a couple of examples, concrete examples of difficult marriage problems solved through hard work, luck, and plain persistence. Our first scenario deals with the wife of Henry Lightfoot. We're going to begin this with a very challenging example from the 18th century, in this case, the very early 18th century. We set the scene in Virginia, a colony where records are lacking in many counties due to the Civil War, and where early death and remarriage was a very common phenomenon. But in whatever era, it's always easier to work with prominent families in counties with copious records. This example fits very neatly into that scenario, and it's instructive because it's not absolutely proven, even to this day. It remains a likely theory, but it's not a slam dunk theory. See what you think. Henry Lightfoot is believed to have been a member of a prominent family from King and Queen County, Virginia. He was consummately literate and had connections in the vicinity of Williamsburg. He was present in the fall of 1705 in the College of William and Mary on a night when it caught fire just before the sitting of the House of Burgesses. We know that because he was mentioned by the grammar master of the college, Mungo Inglis, and also by Colonel Thomas Hill in their written testimony about the event. They both recognized him as Harry Lightfoot and were obviously acquainted with him. Also in 1705, at about 20 years of age, he received a 6,500-acre land grant in northern Virginia, along with a handful of other partners, all of whom were very distinguished men in and around Williamsburg. He is mentioned as a witness in a few records of York County, Virginia. And then just a few years later, in 1710, he moved to Isle of Wight County, where he obtained a position as clerk of court. Now that's a position that he held for 19 years. The fact that he was clerk of court suggests that he was a person with connections, because it required a commission from the governor and recommendations from prominent Virginians to get a post like that. We know Henry's wife was named Patience because after his death, she guaranteed the administration of her son Thomas on the estate of Thomas's wife's first husband. That occurred about 1748. So obviously the father was probably dead by then, or he would have guaranteed administration. Also, we know the oldest son, Bartholomew Lightfoot, was in possession of the land his father owned in that year due to a deed from one of his neighbors. That would be typical of an eldest son whose father had died without leaving a will. Henry Sr.'s estate was not settled until another son, also named Henry, died in 1754. There are two inventories of their property that year, and the only way to tell them apart is not from the actual documents and the pages, but in the index where one of them is labeled senior and the other is labeled junior. Henry Sr.'s estate file mentions all of his children. They were Bartholomew Lightfoot, Henry Lightfoot Jr., who just died, Thomas Lightfoot, Patience Lightfoot Reynolds, and Mary Lightfoot Reynolds. There were also a handful of enslaved people belonging to the estate. Now, considering the methods recommended previously, the naming customs in this family are certainly relevant, as we shall see. But even more important for me initially was to search for the neighbors of Henry Lightfoot and their broader families to see if any of them had unaccounted for daughters named Patience. I found a few, but in the end, this proved a difficult method because Patience, unaccountably, it's an uncommon name in my book, but in that area, in that place and time, it was quite common, and there were just far too many possibilities. I did identify one that I thought was possible, but after the rest of the process, I'm pretty confident that I was chasing the wrong lady. Now, a very frustrating aspect of this problem was that even though he was a prominent person in the community, Henry Lightfoot Sr. left very few traces of himself on a personal level. He only acquired one tract of land himself, but it was not an exceedingly large tract. His appearance in court orders is mostly limited to his years as clerk, and they refer to his official role. He's mentioned obliquely in parish records, but without much detail. We know that he was a militia officer at one time, but that's about it. There aren't a large number of records which mention his personal interests or associations. One thing I did do was check SWIM's Index of Virginia Colonial Records. Now, this is a famous finding aid produced by Earl G. Swim, Assistant State Librarian in the early 20th century, and later a librarian at the College of William and Mary. It covers many of the early state or colony level records that have been published to that date, including Henning statutes at large. It also covers historical and genealogical material published in the three great early magazines that featured family history: the Virginia Magazine of History and Biography, the William and Mary Quarterly, and Tyler's Quarterly. There were a handful of mentions of Henry Lightfoot, which is not a very common name in the index. One of them pointed to a private record, a family Bible that was known as the Breeches Bible, a popular name for a common Geneva translation for Calvinists, that survived in the John Chapman family from Isle of Wight County, and that was reprinted in the Virginia Magazine about 1901 or 1902. You see it here on the screen on this slide. Now, this antique family record was only partially legible when it was transcribed. but it contains some great details about the children that were born to John Chapman and his wife, Frances, the daughter of Thomas Ward, from 1704 when they married to 1727 when Frances died aged 39. John Chapman then remarried to Mary Bevan Marshall. Immediately I noticed that my Henry Lightfoot was a sponsor for the baptism of a younger child, Joseph Chapman, born the 13th of November 1724. Since the first child, Benjamin Chapman, had as his sponsors three relatives, James Chapman, who was likely his father's cousin, his maternal grandmother, Mary Clark, and his step-grandfather, William Clark, it seemed quite possible that Henry Lightfoot was also a relative, and that would be why he was invited to be a sponsor or a witness at this baptism. That was an exciting possibility because Henry was not native to Isle of Wight. He was from elsewhere. But I had to keep in mind that Joseph Chapman's father, Charles, had been the prior clerk of court in Isle of Wight County before Henry Lightfoot came along. Maybe it was just a friendship or a professional association. Also, I couldn't help but notice that most of John and Frances Ward Chapman's children were not included in the list, probably because of illegibility. But one of them was named Patience Chapman. Her marriage to Moses Wills is recorded in 1725 further down the record. Could she have been named for Patience Lightfoot? The Bible shows us that Frances Ward Chapman was the daughter of Thomas Ward and Mary Ward, who later remarried to William Clark. Was there any other evidence that would reveal more about the Ward family? Absolutely. Thomas Ward, the father of Frances Ward Chapman, died late in 1693 or early in 1694. Within a few years, Mary, the widow of Thomas Ward, remarried to William Clark. In April of 1705, William and Mary Clark conveyed to John Chapman and Frances Chapman, the daughter of Thomas Ward, part of a tract of land in Newport Parish on Virgo's Creek and Back Bay Creek, about 150 acres. Mary Clark was to have lifetime rights in the other half of the tract, and after her death, it was to descend to someone named Patience Ward, and she is mentioned in this deed as well, about halfway down. William Clark then died in 1708, and he left Mary a widow the second time. So what does this land transfer mean? An investigation into the history of the tract shows that it was part of a larger one that Thomas Ward received in 1682 as an escheat. An escheat is a bit of abandoned land that had reverted to state ownership and that would then be regranted by the Crown. The land in question had belonged to Peter Hayes, who was believed at the time to have died without heirs. It turned out that Peter Hayes had left a will and that he did have heirs, one of whom was a nephew on the spot named Thomas Bevan. Ward made an agreement with Bevan to divide some of the land between them. He then died, and William and Mary Clark purchased another part of the same land from Thomas Hayes, another heir of Peter Hayes residing in Northampton County, Virginia. This is ultimately the land that was conveyed in part to Mary's daughter by Thomas Ward, Frances Chapman, in 1705, with another part being reserved to Patience Ward, reserving lifetime rights to Mary Clark. It's pretty obvious that these were the two daughters of Mary by Thomas Ward, and that William Clark, her second husband, was trying to secure the future of his wife and his two stepdaughters. If there had been Ward's sons, they likely would have been given the land instead. So could it be that Patience Ward later became Patience Lightfoot? Could that explain why Henry Lightfoot was a witness at the baptism of Joseph Chapman in 1724? Ideally, we would like to trace the later ownership of this tract on Virgo's Creek, but there don't seem to be any other signs of what happened to it. Given the lackluster recording of deeds, that's not too surprising. But further records along the line tend to substantiate this idea. First of all, we know that Henry and Patience Lightfoot named children Thomas and Mary. Could they have been named for Thomas and Mary Ward? The age of Patience Lightfoot is consistent with what Patience Ward's would have been. If Frances Ward was her elder sister, since she married first, we can be sure that Patience would have been born between 1688 and when her father died, about 1694. Bartholomew Lightfoot, the eldest son, was born before 1720, as we know from the earliest appearance in the records, so this is plausible. In 1714, furthermore, Thomas Kirby in North Carolina appointed Henry Lightfoot to act as his attorney in selling some land on Blackwater in Isle of Wight County. John Chapman was a witness to the power of attorney and also to the two deeds by which the land was sold through the agency of Henry Lightfoot. So Chapman's association with Lightfoot predated the 1724 baptism of Chapman's son by at least 10 years. In 1743, Hugh Giles of Newport Parish sold to Charles Fulgham and John Applewhite various tracts of land on Virgo's Creek in Newport Parish, and Bartholomew Lightfoot, the eldest son of Henry and Patience, was a witness on both deeds. You may remember that Giles was a sponsor along with Henry Lightfoot at the baptism of Joseph Chapman. In fact, I think it's quite possible that Hugh was a nephew of Mary Ward Clark. He was also living in the same area where Patience Ward's land lay, Virgo's Creek. And expanding on that fact, we can place the only explicit land acquisition Henry Lightfoot ever made in 1736 at the confluence of Back Bay Creek with Cypress Creek. This area is just to the west and south of Virgo's Creek, which is today known as Moon's Creek. It's just on the eastern outskirts of the town of Smithfield. In fact, the two parcels could have been adjacent to each other. So that proximity is also very encouraging. On this map, you can see where Virgo's Creek is, where Henry Lightfoot's 1736 grant was, or rather the purchase he made, and also a later home that belonged to and was built by Bartholomew Lightfoot, his eldest son, called Six Oaks. So the evidence is beginning to accumulate. Sometimes it helps to organize it so that it can be evaluated as a unit. That's what this chart is designed to do. There's a copy of it attached to the handout if you care to request it. And I've already recorded some of the stuff we've already gone through, some of the evidentiary pieces. But wait, there's more. Bartholomew Lightfoot, Henry's oldest son, died in 1775, leaving a will. In this will, he named several legitimate children, but he also named Frances Willett, otherwise Lightfoot, daughter of Mary Willett. He gave her an enslaved girl and cash. He also gave an enslaved girl and 20 pounds to Patience Willett, otherwise Lightfoot. And he provided a bed and furniture, a cow and calf, and 5 pounds to Mary Willett herself. The otherwise Lightfoot in their names suggest strongly that these two girls were natural children of Bartholomew Lightfoot by Mary Willett. Probably he took up with Mary Willett after his wife's death, but never married her. Note their names, Frances and Patience. Could they have been named for Bartholomew's mother and his maternal aunt? Mary Willett's relationship was with Bartholomew. It was so open that she actually witnessed a deed for him in 1764. It may even be that she was officially his housekeeper, so many out-of-wedlock relationships were thinly veiled in this way. Then, on the 1st of January, 1776, Joseph Chapman was appointed guardian to Mary Lightfoot, a legitimate child of Bartholomew Lightfoot Sr., and also to his other daughter, Anne. Now, this is the Joseph Chapman, born in 1724, the son of John and Frances Ward Chapman, for whose baptism Henry Lightfoot was a witness. Finally, on the 5th of September, 1782, Fanny Willett, an orphan of Mary Willett, came into court and picked her guardian, also Joseph Chapman. She must have been at least 14 at the time to be able to do this. Did these two girls choose Joseph Chapman because he was the first cousin to their father and associated to them in that way? I include these two associations to show that it's important to move beyond the married couple itself into subsequent generations to see if cousins are hanging out with one another and doing things for one another, if they're relying on each other. So in the end, the evidence here was sufficient for me to feel 85% confident that Patience Lightfoot was born Patience Ward. What do you think? The only thing that could prove it is if I could demonstrate that Bartholomew Lightfoot and his heirs were in possession later of the land that they had inherited from the Clarks and the Wards. It may be that they held on to it for over 100 years. This far back, it's very unlikely that DNA would be of any help. But that's not the case with the next example, where DNA can come into play. Now, as challenging as that last example was, the second one might even be more so, um, even though it takes place a little later in time. It involves the wife of George Reeves Sr., a hatter of New Hope Creek in Orange County, North Carolina, just north of Chapel Hill. He died in 1821, leaving a will, and he seems to have resided in the county since at least 1761. Here again, a record loss has to be taken into consideration. Many early Orange County records were destroyed when they were held ransom by loyalists during the Revolution. The individual buried them for safekeeping, and by the time that they were retrieved, they had been more or less destroyed. So from the 1760s to the 1780s, many record books have disappeared, including almost all the deeds. George Reeves was a widower rather early on, and even his wife's given name remains unrevealed in any explicit way. There's no record of a sale of land that required her signature. She may have died between 1787 and 1790. Here, naming practices became very important. I noticed that 3 of the children of George Reeves named older daughters Tabitha, and that led me to believe that George's wife may also have been named Tabitha. I looked round in the community for a family which used this name, and it turned out one of George Reeves' neighbors, a wealthy and influential man named Colonel Thomas Lloyd, had a wife named Tabitha and a son named Frederick. As you can see, my ancestor George Reeves also named a son Frederick. I felt for a long time that this might be the best candidate family, but curiously, Colonel Lloyd's will makes no mention of a daughter named Tabitha, and the associations between the two families in the records weren't particularly strong. I marked that down to the fact that Mrs. Reeves probably died prior to the will being made, and Colonel Lloyd felt no need to take stock of his Reeves grandchildren because they were already well provided for. But as it turned out, I had taken a completely wrong turn. The will of Lysias Durham, who married George Reeves' daughter Sarah, dated 1838, mentions several daughters, one of whom is named Tabitha Gear. Now, this was a record that I was fully aware of, but I had interpreted Tabitha Gear as the married name of the daughter. It's fairly unusual to see a person born in the 18th century sporting a middle name, particularly a female. Middle names came more into vogue in the early 1800s. But as it turned out, when I traced the children of Lysias Durham in their move to Mississippi, I found Tabitha Durham living unmarried with one of her sisters-in-law. She was also found as a single woman with a few slaves living in Orange County in 1840. Evidently, Gear was her middle name, not her married name. She must have been named for someone, perhaps one of her grandmothers. You'll note that there's also a daughter here named Susanna L. Durham, mentioned in this will. Susanna Lindsay Durham was the mother of Lysias Durham. So it would seem that this family named one daughter for the paternal grandmother and another, Tabitha Gear, for the maternal grandmother. But this isn't enough evidence. More was to come. And here's where you see Tabitha Durham appearing under her actual name as a single lady in Mississippi. I was lucky because there were a few surviving records from early Orange County that could help me, including a deed of gift. A John Gear was first to appear in the region. He settled quite early on in what is now northern Durham County on Ellaby's Creek, and he died in about 1770. His will mentions a son, Frederick Gear, and a daughter, Tabitha, who was yet unmarried, as I would expect. Also that year, he gave a slave girl named Judea by deed to his daughter Tabitha. And this is that deed. Perhaps this was in preparation for her upcoming marriage. Now, tax lists show that George owned several slaves early on, and he had even more when he died, several of whom are mentioned in his will of 1821. This is the will. Note that one of the slaves is indeed a woman named Jude, and it was she, in fact, who was bequeathed to Sarah Durham, the wife of Lysias Durham. One would immediately think that the slave mentioned in the deed and the enslaved person mentioned in the will are one and the same, and if so, that provides further substantiation for the theory that George Reeves' wife was Tabitha Geer. Jude's influence in the family and her long-standing association with Geer descendants may have had some bearing on the choice of the name for Tabitha Geer Durham. At minimum, this is a compelling theory. It's certainly not proof of the identification, but it makes a credible case. That's a point I want to emphasize before I close. This method of building evidence to tie females to families of origin often doesn't yield direct evidence of the relationship, but instead we have a persuasive argument, and we simply have to rest on that unless something better comes along. You have to be able to live with some ambiguity and doubt. Also, in this case, it was not the family that was most closely associated with George Reeves through the records, unlike in our Lightfoot example, that turned out to be the most likely candidates for his in-laws. I think I found only one deed in which George Reeves owned land adjacent to David Geer, who would have been his brother-in-law, another son of John Geer. Aside from Lysias Durham's will and the slave named Jude, that was the only other bit of evidence that could have led me in this direction. Perhaps some of the early evidence was destroyed by the desperate Tory outlaw we were talking about. More probably, George Reeves married and moved slightly westward and out of the immediate vicinity of most of the Geer family, which means that even the most passing association may need to be checked out sometimes before the actual family of interest is discovered. That's an important lesson for anyone seeking to undertake this kind of investigation. Interestingly, later, autosomal DNA, or ATDNA, confirmed the conclusion that I previously made in this case. So I am 100% sure that I'm correct about Tabitha Geer Reeves. My father and uncle both inherited DNA from the Reeves family. After all, their great-great-grandfather was Frederick Reeves, the son of Tabitha and George Reeves. Given how close that is generationally, one could reasonably presume that they inherited some DNA from Tabitha's side, and in fact, I was able to isolate a cluster of DNA matches from their results at Ancestry DNA that includes not only descendants of George and Tabitha Reeves, but also descendants of Tabitha's alleged brothers Frederick Geer and David Geer. In each case, we're talking at least a dozen or so descendants in the match list from each brother along several different lineages. These individuals match my father and my uncle, but they also match one another and mostly the same third parties, which is what I mean by a cluster. A cluster is a group of matches who match one another because of one set of common ancestors they all share and from whom they've inherited certain genetic material. Individual matches mean nothing. If I match just one descendant of David Geer or Frederick Geer, it would not lead me to that conclusion. It's only when we cluster them that we start to notice patterns, trace common lines of descent, and draw some tentative leads and conclusions. This genetic evidence is the best proof I'll ever have that my line of thinking through the documentary evidence was correct. DNA simply does not lie, and it can reveal connections well back into the 18th century on certain lineages. However, and here's a big caveat, each of us has clues in our DNA to only certain 18th and 19th century ancestors, not to all of our ancestors from that period, actually to a very small subset of them. One descendant may have significant unique DNA from a given female ancestor, and another may have none. The trick is to continue to test other descendants or gain access to the test results of other descendants until you find the person with the right DNA to tackle the mystery that you have in mind. To find out more about this approach, see my video on the same channel concerning ATDNA and 18th century mysteries. So I end on a note of encouragement. Even though legal and social circumstances may obscure the identity and the lives of our female ancestors, even though local records may be missing or inadequate, I've learned not to give up hope. Within the last few years, I've uncovered or discerned strong leads for the identities of at least a dozen formerly closed female lines. In many of those cases, I'd previously felt a bit beaten down and pessimistic, but you can never know when or where the next clue may arise. Careful reevaluation of former research or new data from deeper research may open a new pathway of inquiry. And then there are cases when genetic results from an individual with the right DNA will open the door. Keep slugging away, keep hope alive for all the ladies in the family. After all, our foremothers' stories are as much a part of who we are today as those left to us by our forefathers. They deserve equal effort and attention. In fact, they will demand even more of our attention than our grandfathers if we renew our determination to discover who they were.